Hi, welcome. In today's video, I'm going to be talking about how to answer law problem questions. Problem questions are usually characterized by fictional names. It will have a storyline, something that you can picture in your head actually happening. The storyline will be related to the fact of a decided case that already exists, and then it is usually long. So the first thing to do before you start answering the problem question is to read the question carefully. When they write in the instruction of your question paper that you should read the question carefully, it's not like a cliche stuff. You actually need to and have to read the question very carefully. So when you're reading the question carefully, you are underlining topics. So the essence of reading the question first is to know the topics under the question. This topic is what will later inform your issue. So when I'm talking about topics, I'm not just saying for you to know that, oh, it's offer. If it's contract, then there's the likelihood that if there's offer, in that same problem question, there could be acceptance, there could be consideration. If the question is on armed robbery, there's a probability that in that same problem question, there's conspiracy, there's provocation, there's murder or manslaughter, right? If the question is on partnership, there could be shares and all of those. So you have to read the question carefully. Don't just read it one part and be like, oh, I know it. Or the fact that it already resembles the fact of a case does not mean that the lecturer cannot add another issue to it. Do you understand? So read the question carefully. While you're reading the question, you're underlining the topics that will later inform your issues, right? So when you're done underlining those topics, the next thing to do is to either on your question paper or at the back of your answer sheet, just anywhere that you're allowed to write jottings, not necessarily answering the main word, you will now raise those issues there. So because the issues could be as little as 2 and it could be as many as 7. If it's a question like maybe under criminal law and there are 7 issues, right? If you list out 5 issues, you might think that 5 issues are a lot. That's probably all the issues that are there, but you will not know that there are still 2 more that you've missed out on. So list out all the issues. The first issue that you should raise is usually the cost. So for instance, if you are answering a question on offer, acceptance, contract, blah blah blah, the first issue that you would raise would be whether or not there was a contract. So write the issues behind your answer sheet or on your question paper. Just jot out the issue in a rough sketch. Maybe if the issue is on, let's choose criminal law. If the issue is on conspiracy, provocation, blah blah blah, just list them out. So when you're done listing them out, the next thing to do is to read the question again. Please don't read problem question once. In fact, even essay question, I would not recommend reading it once. I have a video on answering law essay questions, so you should check it out. The essence of reading it again is to be sure that when you did your first reading, you didn't miss out on any issue, or you didn't miss out on any point that the lecturer puts that he needs you to explain or dwell on. Now, these things might not necessarily be issue. It might just be something that you need to talk about briefly, something that you need to clarify, something that you need to explain in the course of answering the question. So in that kind of scenario, I'd advise that you circle it, because if you underline it, your eyes can skip it and you just count it alongside with issues. But if you circle it, you already know that when you are explaining the main work, when you're already answering the question, you need to talk about this thing, right? So just circle it that your eyes might have skipped during the first reading that you did. So when you're reading it the second time, you need to open your eyes and open your mind to the fact that it is possible that you might have skipped something in the first reading. After you've done the second reading and you've taken note of whatever you missed in the first reading, or you are now sure that you didn't miss anything in the first reading, the next thing to do is to start answering the question. Whenever you want to answer a problem question, you answer it with IRAC. IRAC is a pronunciation of the acronym IRAC, which means I stands for issues, R stands for rules, A stands for application or analysis, and C is for conclusion/advice. Issues are basically the things that will lead to the legal action, right? So if somebody was involved in armed robbery and they took the person to court, right? The issue is like the reason they took the person to the court. So the issue will be like whether the person is guilty of armed robbery. So whether what the person did, right? Whether what the person did actually constitutes armed robbery. So if it's that the person actually carried a gun, that gun, does it constitute armed robbery, even with the fact that, oh, nobody died and the person did not escape before the police came, so the person did not really steal anything before the police came, right? Does it constitute armed robbery? Do you understand? So issues are like the problems that raises question in the courts. The issues are usually written with if or whether. So if the issue is if the person committed armed robbery, the first issue will be if Musa committed armed robbery, or whether or not Musa is guilty of armed robbery, or whether or not Musa committed armed robbery. You get? So your issues should be either if or whether or not. So let me just read out this question for the sake of explanation, and then we'll move into what we're saying again. We're not answering the question, we're not sitting on the question. It's just for you to understand what I'm trying to say. Toti, Vosa, Bossy, and Banky all belong to a gang. They agreed to kill one Mr. Bingo, who they believed snatched Toti's girlfriend. They all got into Banky's van and drove to Mr. Bingo's house in the night. On getting to the house, Vosa felt remorseful when he saw the picture of Jesus with blood dripping from his hands and burst into tears. He turned to leave, declaring to the other that he was no longer ready to go ahead with the plan. This infuriated Toti, who started insulting him and accused him of never following through with anything in his life. He called him a never-do-well and saying that it is his inadequacy as a man that made his wife go out with other men. Whoosh. Vosa was enraged because Toti had betrayed his confidence. He turned round, grabbed Toti, hit him against the wall, threw him off the railings. Toti landed his head and died on the spot. Mr. Bingo heard the commotion and came out of his room to see what was going on. Afraid of being identified, Posey stabbed him repeatedly on the leg. The wife and children of Mr. Bingo raised an alarm and Vosa, Posey and Banky ran away. Mrs. Bingo called for an ambulance. On the way to the hospital, the ambulance driver, Osa, beat the traffic light, causing a collision with another car. In the accident, Mr. Bingo suffered additional head injuries. The medical report shows that he actually died from the injuries to his head. Discuss the criminal responsibility of Vosa, Posey, Banky, and Osa. If you had a question like this now, the first thing to do after reading it carefully is to underline or outline topics that will bring about issues. In this case now, we are going to highlight that Toti Vosa Posey agreed to kill one Mr. Bingo because that is a topic. The issue there is what? Conspiracy. Then they all got into Banky's van and drove to Mr. Bingo's house in the night. That was the role that Banky played there. They used his van. He agreed. They used his van and all of them went into his van. So on getting to the house, Vosa felt remorseful, blah, 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 blah. So he was no longer ready to go ahead with the plan. So Vosa withdrew his consent, withdrawal of conspiracy basically. So this infuriated Toti, who insulted him, and Vosa was so enraged that he killed him. So that was provocation, manslaughter by provocation. If you don't understand what I'm trying to say in this criminal law topic, it doesn't matter. I'm just trying to explain to you that this is how you raise issues. When you see one matter, ask yourself, oh, this thing, what is it under the topic that we've done? Do you understand? So when we see that all of them agreed to go together, what you're thinking of is, okay, that's under conspiracy. When people agree to commit a crime, be sure that you listed out all the issues. You cannot address any issue that you did not list. The next thing to do is to move to rules. It is under rules that you talk about the laws that are applicable. You talk about sections in any law, you talk about case laws, and then you talking about the rules must follow the order of your issues. So for instance, case criminal law, there's a section that defines what an offense is. So you can even write whether or not there was an offense, right? And then if not, you can just define it normally and then move, right? If there's no section that provides for that, you use case laws. If there are sections, you use sections, and you use case law, and you write them according to the way you listed the issue. So if the first issue is whether or not Vosa, Posey, Toti, whatever, are guilty of conspiracy, the next thing to do is to state the section of the criminal code that talks about conspiracy. Section 516 to 518 of the criminal code explains that for conspiracy, they must agree. It must be more than one person, that's two or more persons, and the agreement must be to do something unlawful, right? So you write it out like that. Then the next issue being withdrawal of conspiracy. Section 515 states that, okay, it is best that withdrawal of conspiracy should be communicated before the crime. Posey communicated his own withdrawal when they were at the point of the crime, but then the section says that, oh, it must be communicated before. My point is that it is not under rule that you will start explaining whether or not it is a withdrawal. Under rule, the only thing you do is to state the rules. So when you state the rule of that one, you move to the rule of that one. As you are giving sections, you are giving cases, make sure that you're not exhausting all your cases under rules, because you still need them under analysis, right? So when you're done writing all those rules, the next thing to move to is A. A is application or analysis. It is analysis because that's literally where you're going to like analyze all the issues with respect to the rules, and it is application because you're going to apply those rules to answer those issues. Those issues are problems. They are literally using those rules to answer those problems, right? So it is under application that you're going to do your talking. That's where you're going to express yourself. That's where you're going to quote one justice of the Court of Appeal that defined something. That's where you're going to quote the explanation that they gave. In the case of Alade versus Alade, Obaseki JCA, as it then was, stated inter alia that blah blah blah. It is under there that you start with, according to Black Law Dictionary, a crime can be defined as blah blah blah. That's where you're going to write everything that you know. So make sure that you are writing in a structured and contextualized format, such that as you are writing, like the legal juggernaut that you are also answering the issues under application. Make sure that you are taking the issue paragraph by paragraph to answer it. When you are doing the application, you are not like writing the law again. You can write the section, like section 515 to 517, but then there's no need to repeat the law, since under rules you already quoted the laws. Do you understand my point? So if we said in rules that 515 to 517 state that for conspiracy there must be an agreement, it must involve more than one person, it must be to commit something unlawful, you will not say in your application that these people, they are guilty of kinikon because based on 515 to 517 they agreed they were more than two. So you are literally explaining why the rule will affect them, and you are literally using the rules to answer the issues. So that's what you're going to. So analysis is where you put your mind. If you have any opinion, please by all means write it there. If there are facts, please by all means write it there. If there are cases that you did not put in all the rules, that's where you will put it. You will also use the case. We learned more about 2 or more cases for one issue. You can put one under the rule, put the remaining 2 in the analysis of the application. Do you understand? So that's where you're going to just express yourself, and then paragraph by paragraph you're answering all the issues. Paragraph by paragraph you're answering all the issues. So when you want to start this next paragraph under your application, you can say on the issue of withdrawal of consent, blah, 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 blah. Analysis is where you like really answer the question. The next thing is to move to conclusion or advice. Whenever you have to answer a problem question, the lecturer will ask you to do either one of these 3. The first one is that they will either tell you to raise the issues and advise the parties. The second one, they can either tell you to just raise issues, like what are the issues. The third one, they can tell you to just advise. They'll not tell you to raise issues, they'll just tell you to advise. If they ask you to do any of these 3, your answer is the same. IRAC. That's why conclusion stroke advice, not always to advise. So for your conclusion in this case will be to state what each of them will be guilty of. In this our hypothetical question, for instance, they said we should discuss the criminal responsibilities of VOSA, POSI, Banki, and OSA. So in this case, we're not advising them. What we are majorly to do is to state what they are guilty of, right? So the one that is guilty of conspiracy, the one that is guilty of manslaughter, the one that is even one person is guilty of conspiracy and manslaughter. In this kind of question now that is just discuss criminal responsibility, you don't need to advise. For conclusion, what you're basically going to do is to wrap it up like this contract now. And one of the issues is that was there an offer? After you have used all your application to explain why it is an offer, in your conclusion, you say that between Bola and Aremu, there was an offer. What Bola gave Aremu suffices as consideration. Like in your conclusion, that's what you're going to do. Just wrap it up. Tie the issues to the rules and to the application. But if you have to advise, advising is something that is easy, but it looks like it's not. Because when you're advising, you're basically just talking from your mind. Like imagine you are a lawyer and somebody comes to meet you that, oh, they took a gun to go and rob somebody, but then police caught them before they actually did the robbery. Now they want to charge them for armed robbery. What will you advise the person? There's a likelihood that the case will pass for armed robbery, but if you have a good lawyer, you can find a way around it. Like if you're talking to the person face to face, you know what you're going to say. That's exactly what you're going to write in your advice. If your friend asks you that, okay, so what's gonna happen to this person? Do you know the way the lawyer and you will just rise up and you want to start talking that normally this is what they'll do to you? That's exactly what you're going to write in advice. Advice, where they wrote advise the party, they mean it literally, like advise the party. Like imagine you're talking to the party. So usually I'll start with I advise Bosta that he should look for blah blah blah. You get like what I can't even remember the storyline again. But what I'm trying to say is that your advice should be something that comes from the place of understanding the law. You are an actual lawyer talking to your client. So that's just it. Advice is nothing deep. Just express yourself. Your advice for one person can be a sentence. Can be a sentence. If it's that he's sure that person is going to go to jail, he's sure that he committed it. If it's like rape, they're like, oh yes, he committed this offense. You just advise him that he should get a good lawyer that can bargain his sentence so that his 21 years sentence can be reduced to maybe 14 years. Do you get? Because really, if somebody is guilty of rape and they charge him to court, it's actually going to serve the sentence. So what do you want to advise him? You just advise me, I can't advise you because you're going to rape. That's what you say now. Get a good lawyer because even if you get 21 years, you reduce it. Do you understand? So yeah, that's just it for advice. This is the final video for the law series. I already posted 2 earlier. The first one is how to, nail your presentations, your group assignments, and presentations in class. Second one is how to answer law essay questions. Then this one is problem questions. So make sure to check out the other 2 if you haven't. And I'll see you in my next video. Bye.